The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. This is Tom Glinsky, Chief Inspector with the Board of Pharmacy, and welcome today to our webinar in the series of Lunch with the Chief Inspector. Today our topic is a legislative and rule update, and then we're also going to talk about the employment listing and waiver requirements. So it's kind of a dual topic today. With me today is our Executive Director, Kim Grinston. She will be conducting the first part of the webinar, and then I will conduct the second part. I'm going to go over some of the basic slides for anyone who hasn't been on one of our webinars before. It's set up so you're in listen-only mode. If you have any trouble connecting over the internet to audio, there is an option on the GoToWebinar toolbar to dial in and use the access code on that. This has been approved for 1 hour of CE. You must be officially signed in, which means you've logged into the GoToWebinar website, and you cannot use just the dial-in listening on the phone. You must be signed in and viewing the webinar also. At the end, we have a survey that you must complete in order to get CE. I will go over more instructions at the end of the webinar on obtaining CE and the post-survey. And we do not, the board does not submit CE to the CPE monitor. Handouts are on the board's website. We also make a recording of this that we post in 7 to 10 days. It will be on YouTube. On our website now, we have a direct link on the left toolbar. I've highlighted it here in yellow that will take you to all our webinars, and this is where you'll find all the webinars we've done. You do not get CE for watching recordings. At the end, we have allowed time to answer questions from participants. If you'd like to submit a question during the program to us, go to your toolbar. You can type your question and hit send, and we will go over those as many as we can at the end of the program. So now I'm going to turn it over to Kim, and she will be doing, before I do that, here's our listed objectives. I kind of mentioned them earlier, that we will be going over these two topics. And we're going to do that first, and then we'll talk about employment lists and waivers, and then we'll take questions. So I'm now going to turn it over to Kim.
Good afternoon, everyone. Again, this is Kimberly Grinston, Executive Director for the Board of Pharmacy. And on behalf of the board, we would like to thank everyone for joining us for the webinar on today. As some of you may remember, we began our webinar series maybe about 2 years ago now as a more effective way to reach out and to share compliance information with the licensing community. I am pleased to say that they have been very successful. We have almost 200 people joining us today, and this has been a great forum for us to share information with you. I want to say that we are always looking for ideas. We have events and webinars scheduled through 2014 and 2015. If you have an idea, a topic that you'd like to see us talk about, please go onto the board's website and just let us know. We'll be glad to add that to what we do. Tom will mention this a little bit later, but we have other webinars planned. Beginning next week, we will open up registration for B&DD's annual update that they do for the board. It's going to be held on August 21st, same time period from 12 to 1, right at the lunch hour. It will still be the Lunch with the Inspector series, so we may have some additional information coming from the Chief Inspector, but I want you to mark your calendars for the 21st because we have some additional information coming out on that probably next week on the board's website. So why don't we go ahead and get started. I have a question before we do that. that I want to answer. The question was, does the board have any plans to acquire CE credits to be submitted to the CPE monitor? I want to let you know that right now the board does not submit our hours to NABP, as Tom mentioned. That may come in the future. We're still talking with NABP as they roll out the system, but right now we don't report. Only ACPE approved providers are reporting to CPE monitor. However, after the webinar, you will get an official CE certificate. So if you need proof of compliance for another state, another license, you will get that in the mail. Give us some time because sometimes those will come through. However, you need to stay on the webinar until the end of the webinar and do the question period at the end. Having said that, why don't we get started because we have limited time. Want to make sure that we cover everything. My task today is to talk to you about some of the legislative changes. As you guys may have noticed, the webinar materials went out a little bit later than normal. We try to post those in advance. The governor just finished signing legislative actions on Monday. Monday was the last day to have those signed. So we sort of held off on some of those to make sure that we knew what we needed to discuss today. Also, the board just finished meeting, and we needed to talk about compliance information with the board. So what we're going to do is do a very bird's eye view of some of the legislation that is passed this session that will be effective as of August 28th. Again, August 28th will be our effective date. So some of the provisions you hear today, we are getting questions already. Is it already active or is it effective? The answer is no. August 28th will be the official deadline for those. There may be several other pieces of legislation that may affect your practice that I do not review today. We are going to highlight those things that probably are most important from the board's perspective for you on what you're going to do on August 29th, the day after this becomes effective. But for right now, we're just going to go through some of the bigger pieces of legislation that affect pharmacy practice. Those are Senate Bill 808, Senate Bill 716, Senate Bill 754. We are going to try to post these on the board's website. If anyone's interested, it's going to take some time before they are actually printed in the code. However, if you'd like to see a full version of the legislation now, you can always go to the Missouri General Assembly's website. Just Google Missouri General Assembly, go to Joint Bill Tracking, and then enter the bill number, and you can see a full version of the bill. Again, we'll try to put that up on the website as well. You want to look at the TAFP version or the truly agreed and finally passed version. It will have final language. Other versions of the bills may be online, but they are preliminary versions, so make sure you're looking at the TAFP version. It will take some time to print these in the code. The reviser of statutes is responsible for printing this in the code. That probably won't happen until 2015. So if you look at Chapter 338, for some time yet, you may not see the new provisions, and you're going to have to cross-reference over to the actual bills. Why don't we get started? One of the things that I'd like to note is that all of the three bills I just mentioned are similar. Most of them contain the same language in a modified version. The language is consistent, however, they are under different bill numbers. That happens when we don't know what's going to pass, and so the language will pass over. But let's talk about Senate Bill 808, and I think if I do a summary of Senate Bill 808, you will get a good idea, a good understanding of what's in the other bills because, again, the language is pretty much the same. But let's talk about Senate Bill 808. One of the things that Senate Bill 808 does is it creates a new license class called an assistant physician. Now, we currently have physician assistants. This flips that. These are assistant physicians. Now, my understanding of an assistant physician is someone who has graduated from medical school, who has not completed the full examination process, but is officially a doctor. The law recognized an assistant physician class while they're still going through that process. They may not have been able to get a residency setting and or appointment, and so they may need to wait an additional year or some time before being licensed. The law allows them to work in certain rural areas, and I'll mention that again in just a moment. But there is a new class called an assistant physician. There are some practice restrictions. Again, they can only work in rural areas. They have to work under a supervisory agreement. If you think collaborative practice, APRNs, PAs, this will be something similar to that. We met with BNDD during the most recent board meeting, and BNDD is doing the same analogy. Think of them like a mid-level practitioner. They will have authority to prescribe in classes 3, 4, and 5. This includes controls and non-controls, but their controlled authority is limited to only 3, 4s, and 5s. The rules are required by the Board of Healing Arts, not the Board of Pharmacy. So this one won't be in our field, but it will be through the Board of Healing Arts. So this is not effective yet. Yes, the statute says that an assistant physician can prescribe, but rules have to be done by the Board of Healing Arts, which I understand may take some time. So if you get a prescription today or after August 28th from a quote-unquote assistant physician, first, the license class won't exist, but until those rules are effective, they will not have full prescriptive authority. And I understand BNDD also may need to do some additional executive and administrative things before they can add them and grant them a controlled substance registration. But I just want you to know that the license class is now out there. Immunizations, and this is probably something that we're getting questions on already. Our immunization authority has been amended. We, as you all may know, the board proposed or wanted to support legislation that would allow a pharmacist to administer any vaccine. That legislation didn't pass this year. However, we did have legislation pass, and not when I say we, I mean it was brought by, I believe, the Missouri Pharmacy Association, and this year the General Assembly approved expanding pharmacist authority to include Hep A and B and Tdap. This becomes effective August 28th. Again, we're getting calls already on when can I get started. Not until after August 28th, when the law becomes effective, will you be able to administer Hep A and B and Tdap. There are some changes to the immunization authority that won't look very different for those administering by protocol, but by prescription it would. The statute officially codifies what's in the board's current rule, namely that you have to notify the PCP if different than the authorizing physician on the protocol within 14 days after a vaccine. This is mandatory. This has always been the rule for vaccines administered by protocol. This now applies to vaccines administered by prescription. So if you are doing it by prescription, you are still going to need to make notification to the primary care physician within 14 days if different than the authorizing physician. The law recognizes that vaccines by protocol must comply with CDC guidelines. Now, we have some language similar to this in the rule, but this is slightly different in the statute. And Tom, I don't know if you can give us some more information on that one.
Yeah, our current rules say in compliance with CDC guidelines and manufacturer guidelines, and the case that comes to mind is Zostavax, where the two guidelines differ. CDC is 60 years and the manufacturer is age 50. The statute, once it becomes effective, will not allow you to do it outside of CDC guidelines. So Zostavax, after that, will not be able to be given to anyone under 60 once this becomes effective. However, you could still do it by prescription order to someone under 60. So that's an example of how this will affect what we currently have in our rule.
Thanks. A couple of other things in the language that I want you to know. The language now says that a pharmacist, and you'll see this on the screen, who's administering a vaccine must ask a patient to remain in the pharmacy for a safe amount of time after administering the vaccine. It also requires a pharmacist to have adopted emergency treatment protocols. Now, ideally, this should be in your protocol already, but now it is now mandatory to have an emergency treatment protocol. The question we've gotten already is, what is a safe amount of time? Statute doesn't define that, and we probably will talk with the board about and ask them if further definition is required by rule. Pending a final rule, the board is recommending, and the board voted on this on Wednesday, that pharmacists use their professional discretion when determining a safe amount of time. And so, again, this is going to be within the discretion of a pharmacist to determine what actually is a safe amount of time for a patient. Again, the expanded immunization authorities effective 8/28/2014 cannot be done today. You do not need to file a new notification of intent with the board. Now, as we enter the renewal period, I want to stress this very heavily. You don't need to do a new notification of intent with the board. When we amended our rule some years ago, I think the last amendment was 2 years ago or so, We amended it so that if there were vaccines added to Chapter 338, that we wouldn't have to go in to amend the rule again. This is a question, Adam, I see that you submitted. We don't need to do further rules to implement this after August 28th, except for defining things like a safe amount of time. Once August 28th comes in and you have an NOI on file with the board, you can go ahead and start administering the new vaccines, with one exception. A very important one that I'll talk about in a moment. But a new notification of intent is not required. Your NOI allows you to administer any vaccine authorized by Chapter 338 as long as it's also authorized in your protocol. And this is our next point. The new vaccines must be in your approved protocols. Right now they shouldn't be because it's not an authorized vaccine by protocol. So those protocols will need to be amended to include the additional vaccines. You cannot provide Hep A and B or Tdap under a protocol unless the protocol specifically says so. That means it may need to be amended. Your protocol would need to be. It must be signed and dated, and that's required in the rule by both the pharmacist and the authorizing physician. We get questions on how do you do that. Ideally, you all should be signing the same document. Redo the document, add the new vaccines in the document, and then re-sign again. I know there are several protocols out there that have multiple pharmacist signatures on there. We have allowed in the past other ways of signature, statements that are attached to the protocol that says both parties are agreeing to amend the protocol to include the following vaccines. What we're looking for is a signature, a date, and something that shows us that both the pharmacist and the physician have agreed to add the additional vaccine. So if you know August 28th is the effective date, you all maybe want to begin working on changing the protocols now so that you'll be ready to go on the 28th. The statute talks about additional training for pharmacists who are immunizing. That training is already included in our rule. So there's no additional training needed to implement the new provisions. You should already be trained if you filed an NOI. If you haven't filed a notification of intent, the training requirements are in the rule, and you can follow those for the new vaccines as well. It says training included in new rule. I need to qualify that. Not in the new rule, in the current rule. This should say the training's already included in the current rule. Again, you're not waiting for anything new to come out on training. Statute also provides that you must post an immunization certificate in the pharmacy, and it requires the board to issue a certificate. We talked with the board about this, and on Tuesday the board voted that they will not be issuing a separate certificate. So you are not waiting from anything else from the board. We're not going to do a separate document. However, the law does require that something be posted in the pharmacy. The board is allowing two things. You can either, one, post your notification of intent confirmation page, and that would have been the confirmation page that you received when you submitted your notification to administer vaccines. Hopefully you retain that. You can submit that if you'd like. Or, number two, because I understand some of you may no longer have that, the board publishes a public list of everyone who has filed a notification of intent and given us a permission to make their name public. That list is currently on the board's website, and I believe we update that weekly, maybe bi-weekly. I'm hearing, yes, protocol only. Protocol only. The NOI list does not apply to administration by vaccines, and we will have that posted. But what you can do is you can print the NOI list that is currently on the board's website, and it will have your name on it. Again, for those administering by prescription, we will have something posted before the 28th. You can post that list in the pharmacy. You can either post the name with your page on it, or you can keep the entire document posted. Alternatively, the board approved keeping the list electronically or just making it accessible at the pharmacy. When we go in to do an inspection, it should be there. So if it's in a drawer or if it's available electronically, you can pull it up online. That is fine with us as well. Again, we'd like this to be as seamless as possible. We're getting calls already about the certificate requirement. Use your NOI. Use the board's NOI list to post. Notification of intent, the public listing, this is where it is. You'll see it highlighted. This is a shot of the board's webpage with a very nice advertisement for the board's patient safety conference. But you'll see the highlighted area on the left, and this is what the NOI looks like. Now again, this only includes those pharmacists who indicated that we could make their name public. And so if you filed an NOI, you're not on the public list and you want to be, please give us a call. We are unable to reprint NOI confirmation pages in the office. So you're going to need the NOI list. You can call the board's main office and we'll begin to do that. Again, we should see everything updated by August 28th. I was going to move on to hospital pharmacy, but before I do that, we have just a few additional questions that I want to address now. Will the prescriptive authority for assistant physicians be limited on C3s? I have to check the bill again. I don't know that there's a limit in the bill. I know there are rules coming out, so I don't know the answer to that question. I believe the answer is no, Adam, but again, the rules are coming out and I don't know how that works. What is going to be the credential for an assistant physician? I don't know. I don't think the Board of Healing Arts knows right now. They're going to work that through. We should, and we'll give you more information once we know what it's going to be. Okay. We have some other questions that we'll get to at the end of the webinar. I want to finish with 808 and then turn it over to Tom. Hospital pharmacy. Senate Bill 808, as many of you know, the board convened a hospital pharmacy working group to address the board's regulation of inpatient hospital pharmacy services. The board has always regulated outpatient hospital pharmacy services. Senate Bill 808 contains provisions that were proposed by the board in conjunction with the working group to address hospital pharmacy. One of the bigger changes will be that there is no longer a Class B hospital outpatient pharmacy license. Instead, it will be just a Class B hospital pharmacy, inpatient or outpatient. The law allows facilities and clinics, and this is very important, that are under common ownership with the hospital or hospital system to be eligible for a Class B hospital pharmacy license. So you have the pharmacy, the hospital that's in one area and a clinic in another area. If they are under common ownership, they are eligible for a Class B hospital pharmacy license if requested. Now, let me tell you what 808 does not do. 808 does not give the board full regulatory jurisdiction over inpatient pharmacy. It allows joint rulemaking with the Department of Health, and we're limited to just dispensing meds by the pharmacy. This would not include floor meds or other professionals like nurses. We will not be working on rules relating to nurses. Additional guidance is going to be coming out on the hospital pharmacy provisions from the board, so I'm not going to go much more into those at some time. Continue to check the board's website, and we may actually do a separate webinar just on the hospital pharmacy provisions, but please know they're out there. The other area is military licensees. That's included in 808. This won't be anything new for most of you on the call, but the board doesn't have jurisdiction over federal property. Every now and then we get a call asking us about pharmacists practicing maybe in a VA hospital. The law has been amended to allow or to recognize that if you're practicing as part of your official duties for the federal government or as part of the armed forces, you do not need a Missouri Board of Pharmacy pharmacist license. Now, they can't hold themselves out as a Missouri licensed pharmacist. They are a pharmacist, but they can't say, I am licensed in Missouri. It must be part of their official duties. Sometimes we have pharmacists who work at the VA hospital at part of the time and maybe at a retail store in the evenings or something of the sort. If you are not working as part of your official duties, you need a Missouri pharmacist license. Again, there isn't an exemption for those pharmacists who are working outside of their official activities. Finally, and this is just, well, something that may not affect most of you, 808 contains a new provision that requires Social Security numbers on your first renewal. For all of those renewing for the first time, not for the second or third time like many of you probably are, after August 28th, interns go into renewal at the end of the year. We will be looking for a Social Security number. We can no longer accept visa numbers or passport numbers. I think this will probably impact our interns and some of our technicians the most. Again, this only applies if you're renewing for the first time after August 28th. A few other regulatory updates, and then I'll turn it over to Tom. We are still working on revising the sterile compounding rule. We anticipate making a draft of that available to the public, not filing the draft, but a discussion draft available to the public within the next 2 to 3 weeks. So please continue to monitor the board's website for that. Pharmacist renewals are going out. I want to remind everyone renewals will be mailed right around the second week in August. It must be renewed by October 31st of this year. The board, in response to all the comments from licensees, the board amended the CE deadlines. For this renewal period, your CE has to be earned between September 12th and October the 14th. September 1st, 2012, September 1st, 2012, and October 31st, 2014. So that means we no longer have the staggered dates where CE is due in August, but you renew in October. You have until October 31st to get your CE done. But I want to know, your CE has to be done in order to renew. You will not be able to renew until your CE is completed, because you have to attest that your CE is done in order to renew, and that's online or on paper. If you wait until October 31st to do your CE, you will not be renewed in the board's records for at least probably another week or so. So you will not show up with an active license on the board's website, and you will not be renewed in our system. Although you have until October 31st to complete CE, again, your renewal will not be processed on the 31st, and you'll have some downtime when you're not eligible to practice. So note to everyone on the call, please complete your CE early. Do not wait until October 31st. We want to make sure it goes seamless. Final thing that I'd like to note, the board under our statutory authority is only authorized to collect fees to administer the chapter, Chapter 338, to do what we do: license, regulate, inspect, and investigate. If those fees, if we see that we are collecting more money than we need, we are required by statute to address it, either by lowering fees or taking other measures. So the board voted to reduce renewal fees for the 2014-2015 renewal period. Effective tomorrow, pharmacists, your renewal fee for the 2014 renewal year is $50. Now, I have to say that is a one-time renewal decrease. We will look at the fund again in 2016 to see if that fee can stay at that level. But for the 2014 renewal period, your renewal fee will be $50. Interns are coming down to $20, and techs will possibly come down to $20. The rule has been filed, but it's not yet effective. We don't anticipate any changes with that, but for the 2015 renewal period only, we anticipate a $20 renewal fee for our technicians. Again, the board was very excited about doing this to make sure that we, first of all, are collecting only the money that we need from our licensees to operate and do what we do here at the board office. Those are the legislative updates I wanted to share with you. I'm going to turn this over to Tom as we reach right about 12:30. I have several questions that have come in, and we'll add a block of time at the end to answer some of those. So, Tom, thank you, and I'll turn it over to you.
Okay, thanks, Kim. Today I'm going to just talk about the board's employment list and BNDD and DEA waiver requirements. And I'm going to start with the board's employment list. We have three lists: the Technician Employment Disqualification List, otherwise known as the EDL. We have the Technician Conditional Registration List, and we have the House Bill 600 Suspension List. I'm going to talk about all those in more detail in just a minute. I'm going to briefly talk about the federal OIG exclusion list, just because it is a list. The board doesn't have anything to do with that list, but I wanted to mention it. The Technician EDL list is a list of technicians who have been disqualified from working as technicians in pharmacies by the board. There's two avenues that the board usually comes across these type of people. And one is through the application process. They file an application with the board, and either their criminal history or something else in their history, maybe something with another board, the board has concerns with and has voted that they should not be working as a technician in a pharmacy. The other avenue is through the investigative process, and this is usually technicians who are already licensed with us. They have done something in a pharmacy. Diversion is the most probably a common one that the board investigates, and based on that investigation feels that the pharmacy tech should not be allowed to work in a pharmacy. All of these are based on individual board's decision. The board has to review each one of these individually and make an individual decision on what to do with the technician. The board currently can EDL a technician for up to 5 years. That would be the maximum. And if the technician wants to come back after the term of their EDL is up, they must reapply just as they were, as if they weren't licensed. The conditional registration list is a similar list, but these are technicians who the board has reviewed but will allow them to work with conditions. And I say this is more like a probation type thing. And again, the same two avenues apply here on where these stem from, either through the application or investigation process. And again, each one of these is an individual board decision. Technicians might call and ask the office, I have a marijuana possession charge from 5 years ago, will the board give me a license? We cannot answer that because the board reviews each case individually. Again, they can be on the conditional registration list for 5 years. And this, they get issued a certificate, and on the front of it, there will be a phrase that say restricted C reverse, and then you have to turn over their blue certificate and you will see the conditions of their registration on the back. Some of them, there's some standard ones such as keeping the board notified of your address, following all the laws, and then there could be specific ones. The most common one is the requirement for urinalysis. Random urinalysis might be printed on the back of that. So if you have a technician who is unconditional, you must turn their certificate over to see what the conditions are. The House Bill 600 suspension list, this is related to personal income taxes. It was created by a statute. It's statute 324.010. This is not a board statute. This is a professional registration statute. So it affects all boards here in the division. It was created in 2003 by House Bill 600 that legislative year. So it's known throughout our division as HB 600. It's an automatic suspension. The way this, based on you having outstanding personal income taxes over the last 3-year period. The Department of Revenue is the driving point behind this. The boards are basically just the messenger in the process. The way this works is if a licensee has a outstanding issue, I understand Revenue contacts them to try to work out either having it paid or some type of agreement finalized on payment. They work with them, but after a certain period of working with them, if it's not resolved, they then notify the boards that here's a list of people who will be automatically suspended. And then the board will send a letter to the licensee telling them that within 30 days, if they don't get this resolved, they will be suspended. And then after that 30 days, we get another list from Revenue and tells us who we have to suspend. There is no board decision in this at all. It's automatic by the Department of Revenue. It affects all of our licensees, so pharmacists, interns, and technicians. And the Department of Revenue is continually reviewing, so we get these throughout the year. They're usually a massive list after renewal periods, and then the other lists are based on new applicants that come in over the year. So about once a month, I would say, or every 2 months, we get lists, and there'll be suspensions based on that. These lists, it's kind of known, we think of them as a technician list because they make up 99% of the licensee on the list, but we have had pharmacists and interns on the suspension list in the past. I'm going to just talk briefly about the OIG exclusion list. The board is not involved in anything, but it is a similar list. It's related to Medicare, Medicaid, and other federal funding. Anybody that meets, it's spelled out in a regulation on who they can disqualify. Some of it's mandatory. Some of it is they have some options on exclusions. It applies to both individuals and entities, so pharmacies can be on the list. To get reinstated, the person must request reinstatement. It's not automatic when their time is up, and there's a searchable list on the OIG's website. Now with Part D, most pharmacy people in management are aware of this due to its requirements for to be checking that list for Part D compliance. We post these lists on the board's website. Our 3 lists are there, and we update them regularly. On our website, on the left toolbar, it's all found under technicians, and this is because the suspension list is mainly technicians. But you find all 3 of the lists here. I have them circled in red. And what you can do is click on that list, and this is what the EDL, the employment list, looks like. It will list pertinent information about them, and then their effective and end date of the EDL. You will notice some do not have a registration number. That is because that is one that was based on an application, and the board denied them at the time of an application, and so they never were issued a number. Let me caution you, the information on here is only current at the time of their application. This does not update. The registration number would stay the same, but the address and city, and that will be they could move around, and the board does not track that. This is a similar list for conditional registration. Again, all these people do have licenses because they have been allowed to work, and they have a beginning and end date on that. Again, if you want to know what the restrictions are, you have to go back to the licensee's actual certificate to see the actual conditions. This is a copy of the what the House Bill 600 list looks like. It is updated regularly. I will tell you, the ones in red are the new additions to it. The last updated in that date, usually it doesn't coincide with additions. It's being updated with people being taken off the list. So when you look at this list, the ones in red, there's one on this one here. That was something that was added since the last time we posted an email alert. But the date updated, there could be people who have been removed from the list since that one was added in red. People ask, well, do you notify the pharmacies when someone goes on these lists? And the answer is not directly. The board does not directly notify anyone on any of these lists. However, we do post it on the website, and we do send out the email alerts. That is the only source. If you want direct notification, you must be signed up for those. And here's a sample taken from an email alert. We post in the email alert the new additions to the list, and the same would apply for House Bill 600. It would just be a list of who these people are. And again, the address may or may not be the most current. The other topic I wanted to talk about was B&D and DEA waivers. These, I think, are so some pharmacies unknown. They aren't aware of the requirements, and others just do not understand how they work. So I wanted to spend a little time going over these, even though the board is not involved in these, what I'm going to talk about here. But both agencies do requirement. They have a difference in what they require. They're based on regulation. I cited the B&DD and the federal regulation on where the authority comes from. And what a waiver is a registrant. So in this case, it's a pharmacy who is the registrant. In order to employ people who have access to controlled substances, who have a prior controlled substance related conviction, you have to request a waiver and be approved in order for them to work in your pharmacy. I want to go back to access to controlled substances. People ask us, well, what does that mean? We refer them to the agency and let them, because this is their regulation on what that actually means. So anybody has a question of what does access mean, please contact B&DD or DEA. This is the difference on who needs one, and B&DD requires anyone with a misdemeanor or felony conviction. DEA only requires felony. So the state is stricter here on any on what the conviction is. This requirement will last for the life of the employee. If they change jobs, they still need it. If the example we get is someone in their 50s who had a possession charge when they were 18, they still need a waiver in order to work at a pharmacy with controlled substances. And even if they request it, the agency may or may not grant the waiver. They do have some guidelines on when they will issue waivers, and so it's not automatic that you get one. But again, it's the pharmacy that is requesting it. It's the registrant's responsibility to know who they're employing and who needs one, and they're the ones that have to request it. It is specific to the registrant, so if they're floating among a chain, each chain location would need to have one. And again, we refer direct questions to the specific agency. There is more information on the websites. BNDD's October 2001 newsletter had a section on waivers. The DEA Pharmacist Manual also has a section on waivers, and the DEA has on their FAQ page a section on waivers. So I would suggest you go to their website if you have any more questions. Who could be accountable by the board for issues with this? And let's say an example would be a pharmacy continuing to employ a technician on the suspension list. The pharmacist in charge is responsible. The permit holder and the individual licensee involved could be held responsible. If it's a waiver issue, then the BNDD and DEA registrant could be held accountable, which in this case would be the pharmacy. I wanted to give you some examples of cases that we've had that involve this. The most common one I think we investigate is House Bill 600, and the reason is the pharmacy was never made aware of it. And I don't think I've ever been told, well, take that back, I have been told that it has occurred, but normally your employee is not going to come in and show you a letter that says I'm being suspended, because then they would lose their job. So they don't come and tell you about it, and the only way you find out about it is, if you're not watching the email alerts, is at renewal time. You can renew a suspended license, but they do not get a certificate mailed to them. So they will renew, and when you ask them to bring their certificate in, then they never get one. Someone calls the board office, and the board office will tell them the reason they didn't get a certificate mailed is because they were suspended 6 months ago. And that is probably the most common violation of dealing with these lists. I will tell you there are a couple cases involving diversion. There was a pharmacy that had a large diversion of pseudoephedrine. Over 5,000 dosage units of pseudoephedrine were taken from a pharmacy. It turned out that the technician that took them had a prior controlled substance conviction. Would have required a waiver to be in the pharmacy. And one of the largest diversions in the state of Missouri, where over 200,000 dosage units were diverted from a pharmacy, involved a technician who the last 8 or 9 months of their employment at the pharmacy were actually on the House Bill 600 suspension list. And if the pharmacy would have realized that, they wouldn't have been in the pharmacy. Again, the pharmacy, if they would have known and taken these actions, they would have saved themselves some of the problem. The diversion had already been going on. Suggestions I have is sign up and read the email alerts. I will just tell you, we had a presentation at the board meeting about the percentage of people that open the email alerts, not ours, but another groups. And it was like 20% people actually opened them and read them. So I always tell people to sign up for them. Now I've added and read them. Review your hiring process. I cannot give you legal advice on, I've been told that people say, well, HR won't let us ask such questions on what your past criminal history is and do you have anything pending and stuff like that. I can't give you advice on that. My suggestion to you is go back to your HR and show them the regulations that require you to know that, and let them come up with a way to assist you in that. Do not rely on the board's licensing of a technician to mean they don't need a waiver. The board issues registrations to technicians who need waivers. The board has deemed them not a risk, and have given them one, but they still need a waiver. So just because someone has a technician license doesn't mean they don't need a waiver. Review the technician application. All pharmacies are supposed to have a copy of it. If they're honest, they check on that they have prior history. You could find out that way. I know pharmacists submit them without the pharmacist in charge ever seeing them. Do not assume others in your organization are doing this for you. As pharmacist in charge, you are the one ultimately responsible. We've had times saying, well, we thought HR took care of this for us. And again, educate your staff, educate your technicians that if they do get letters from the board, they need to respond and take action. It's not going to go away just by ignoring it. We now are going to open it up to questions that we have received. Just to go back Kim talked about the CE one. We have a follow-up that says, are we required to report to the CPE monitor? You are required by ACPE if you want ACPE credit. The board does not have anything that specifically says you must do it, but the ACPE now requires you to if you want to get CE from them. Okay.
Yeah. A couple of questions on immunizations.
Okay, this one is about how do you know who the, we have two questions here about how do you know who the PCPE provider is on the immunizations now that you have, if you're doing it by prescription. Our rule does not talk about this. This is something new. You would need to ask the patient who your PCP provider is, and then that's who you get. Most of the time I see people using the same form that they use to do protocol, and it's already on there. They have a field for that. So I would suggest using that, or if you have a separate form that you do as your administration record by prescription, add that to that so you are asking that question on that. If it is different than the prescriber of the prescription, then you need to notify that PCPE. We would be going to the vaccine administration record and asking you, well, did you ask that question and who it is?
And if the patient doesn't give it to you, let's say you ask and the patient doesn't know, doesn't have one, doesn't give it to you, then you're not required to notify someone if you don't know who they are. But you should be making an attempt to ask and find out who the PCP is.
Someone's asking, can we just post our APHA certificate to meet the statute requirement? And the answer is no, because the statute says the certificate has to come from the board. So it's going to have to be something that the board generates. And right now, the notice of intent that Kim talked about, those methods there would be the only way that you can do that. Let me see if we got any more about immunizations.
Yes, we have one here about adding the new immunizations. Your protocol may be expiring at the end of July. Can you add the new immunizations now? I don't think there's a problem with writing in the immunizations, but I would suggest adding effective 8/28 so that it's very clear that that authority isn't effective until then. Rule doesn't specifically address this, but I would suggest if you add them now that you add something that says effective 28. I'm sorry, August 28th.
And I do want to clarify a little bit on what was added. Kim mentioned Tdap, but the statute actually says diphtheria, tetanus, and pertussis. So right. Tdap would be a combination, but it could be individuals of each of those or other combinations of those. So it opens up a wide variety of more immunizations, vaccines you'll be able to immunize with, not just Tdap. But Tdap was the push behind this, and the big talk over at the Capitol and to get this through was concerns about Tdap.
That is correct. Waivers.
Okay, let's switch topics. We'll go to hospital. Someone asked, can they go ahead and apply for the new Class B that's defined in the rule? And let me find that.
I'll answer that question. No, we won't be accepting applications until after August 28th. If you currently hold a hospital outpatient pharmacy license or another pharmacy permit from the board, the statute does allow you to submit an application without a fee until January 1st of 2015. Again, we'll push out more information on getting that done probably in August, so that we'll give some more guidance. I have an interesting question. Someone asked, what is the benefit of a Class B pharmacy? I want to clarify. The board will not have jurisdiction over inpatient hospital pharmacy practice. The Department of Health will still be regulating inpatient hospital pharmacy practice. 808 contains some language that would allow drugs to be transferred and or provided to other entities that are under common ownership of a Class B hospital pharmacy. So maybe a clinic, an infusion center, a chemo location that's not part of the hospital premises. That's one of the benefits of being a Class B hospital pharmacy. However, the law says that if you're doing inpatient only, if you're doing activities that are under health's jurisdiction only, that you're not required to get a Class B permit. You can if you'd like, but it's similar to where we are now. You're not required to have one if you're solely doing inpatient activity.
Okay, we have some questions on waivers and employment lists. Somebody wants to know, are pharmacists included in the? Yes, anybody working in a pharmacy around controlled substances, it would apply. It would apply to people who aren't even our licensees. So keep that in mind. If they have access to controlled substances, they need one. An example, again, I think you need to ask B&D and D&D to clarify what is access. Someone wants to know, when you do a technician search on our website, does it show that they need a waiver? The only way it would is if they have a conditional registration and in the description of why they were given one, it says due to a conviction. Other than that, there would be no way. So I would not rely on that as a way to say I'm checking for it.
And if I can add something there, this is where Tom's recommendation really comes into play. Make sure you're doing a good background check on your own. The board is limited on what we can provide by federal law. We do an FBI check, and as part of that check, we have severe restrictions on who we can give that information to. So even though we may know they need a waiver, federal law prohibits us from providing some additional information. So that's the reason why we just don't call and tell you. We'd like to. The board actually had a discussion about this on Tuesday, and maybe looking at ways that we may be able to do that. But a good check, asking the technician, would probably be the best way, and or looking at the conditional registration letter.
Okay, someone wants, does the board review background of all renewals to check for convictions? No. You have to report them to us, but we don't go through and run a background check on everyone that renews. We only background check new applicants and investigation, tied to investigations, we might do background checks, but we do not do it for renewals.
There's a question on the $50 pharmacist renewal fee. Yes, it is for the 2-year renewal period. So for 2014 to 2016, the $50 fee does apply for that entire 2-year period.
We have a question on the new Class B definition. They want to know if it's under the same ownership but located at a different address, would only a Class B license be needed? The answer is yes. Could be. That would cover it. However, if you do other things, sterile compounding, that you might have other classes, but it is a choice. You don't have to be. You could still be a Class A, which I would assume that what you are now. You will get, if you go the Class B route, once the rules get published and in place, it gives you more leeway on how you do such things. The intention is to give you more leeway, such as record keeping, numbering, stuff like that. We've got another question. How do you find out if a waiver is needed? The board does not tell you. DEA will not tell you. It is the registrant's responsibility to know if your employees need them. This is, again, this is not a board requirement. If you have questions, you need to direct them to BNDD and DEA if you have questions. And this is a good plug for our next webinar. BNDD's Administrator Mike Boger will be here. I expect we will be getting questions on waivers.
And we'll ask Mike to please add that to his presentation as well. But again, if you have a new applicant, the best way to catch it is to do your own background check. Check the available state databases. There are services available. Of course, the board can endorse them. If they are EDL'd because of their criminal conviction, no waiver is needed because they're not allowed to work. If they are conditionally registered, look at the conditional registration letter. It will tell why they were conditionally registered. If there is a crime related to controlled substances, it will be in the conditional registration letter. Another reason why the e-alerts and having that information is very important.
We have someone wanting to know, is there a time frame on if someone gets a suspension letter, by the time they got the suspension letter, they are suspended. There is no grace period. If you find out someone's on the suspension list, by the time the email goes out, they are suspended. So they need to be removed from the pharmacy. They are not currently licensed.
And I'll stress very quickly as we look at the end of the program, that's because their suspension is not done by the Board of Pharmacy. It is by operation of law by the Department of Revenue. So once Revenue says that they are suspended, we are required to suspend them on a certain date designated excuse me, by Revenue. We can't give a grace period. We can't pull it back. Unfortunately, that is usually a Saturday, I'm being told. And again, that's the Department of Revenue. So unfortunately, no, there isn't a grace period. Once they're suspended, they are suspended.
We have an asker wanting to know about using electronic signatures for protocols. Someone did ask someone has asked this question, and basically if you want to do that, I would suggest you send me information on how it's going to work. We would like someone to give us their how it would work so we can take it to the board and ask them, do you think this would qualify? Someone has floated the idea out there, but we don't have the specifics on how it will work, what the pharmacist will be seeing when they attest to it. How do you know that's the pharmacist doing it? So the asker would be best to email me, and I will work with them if they have a plan and see if we can't get the board to look at that.
We have one last quick question that someone's asking. Should a pharmacist note if the patient says they don't have a PCP? It's not required in our rule, but I think best practice would be to note somewhere that the patient said they didn't have one.
And our last question will be, someone's asking about designating between pharmacists and technicians CE for this program. We do not assign numbers that do that. That is an ACPE program. This is not an ACP approved program. This is board approved. We do not say that. We would not have a problem with you using it, but that's up to your PTC board.
And we've had technicians ask in the past. We have issued certificates to technicians. So if they ask for a certificate, they will get one from the board showing that they've completed the CE.
Okay, so as I mentioned, our next Lunch with the Chief is going to be October 21st with Mike Boger, the administrator from BNDD. We ask if you have questions or topics, please submit them in advance to compliance@pr.mo.gov. If you would put in the subject line webinar or webinar questions, it would be of assistance. And we give him questions in advance so he can be prepared. We will also take them live during the program. After that, the next Lunch with the Chief webinar will be October 15th. This is going to be, right now it appears it will be talking about pharmacist administration. We will talk more about some of the statute changes that occurred this session. And as Kim mentioned on one of the slides that we have an upcoming event. Kim, do you want to talk about this?
The Board of Pharmacy, the Board of Nursing, the Dental Board, and the Healing Arts will be doing for the first time ever in Missouri a joint regulatory patient safety conference. This is a free event. It's been approved for 6.4 hours of pharmacy CE. It's going to be in Columbia at the university from 9 a.m. to 4 p.m. More information is on the website. This is part of us promoting patient safety, free CE. Spots are limited and we are filling up. So if you desire to go, please go to the board's website and register today.
And that on the board's website is this flyer. It gives you more information, and there is also a link to registration. Again, in order to get CE, you have to do the webinar, the survey at the end, so do not close your browser. I will tell you that we're closing the webinar, and once I do, in a few seconds, a window will pop up that has a survey on it. I will warn you, if you're doing this on a mobile device, a smartphone or a tablet, you may not receive the survey. We know there are problems. GoToWebinar knows people don't get the survey sometimes on those. If you do not get them, send an email to compliance@pr.mo.gov and we will email them out to you. In order to get the CE, you have to have, if you do get it by email, you have to have it back within 48 hours. And again, we will send out certificates in 7 to 10 days, and we will have a recording of the webinar up in approximately a week. I am now going to close the webinar.
Thank you everyone for attending, and hopefully we'll see you on the 21st.